I am the applicant.
Why you need an adjournment? Why you need an adjournment?
2 weeks. I'm not so prepared. So my one side eye and ear is disturbing me. So for medical ground,
You are Mr. Udeka?
2 weeks time.
You are Mr. Udeka?
Yes, I'm staying.
The request of swear the conflict with the others. This came after 2 weeks. 2 weeks time.
Yes. I did.
Mayor, Lordship, I beg to mention item number 16. As the opposite council could not come today,
Who is the engaged council?
we have taken the council.
Who is the engaged council?
M. Kato. I'm for the petition. As they are not coming,
M. Katu is not coming.
no.
Otherwise, you are ready or you are also not ready.
I'm also not ready.
Just after 2 weeks. Your good name was?
The type, but yeah.
The title is so and so, the request of so and so, and the concept of the other sides. The prayer adjournment, prayer for adjournment was made, let them to be listed after 2 weeks.
Obliged.
Mayor, my lordship, I beg to mention item number 3 on behalf of Mr. S. Tapin. This matter may be listed on 3rd August, my lordship. I have taken consent from the respondent.
3rd August, I can say, because 3rd August, most probably the other some hearing matters are fixed. Let it be fixed on 9th of August.
Mayor, Your Honor. And I beg to mention 2 unlisted matters to be taken up today, Your Honor. One is appeal and one is a 389 petition.
One is
Appeal against conviction.
unlisted matter for today only.
Yes, Your Honor. If Your Honor,
So I have a VC on the, from, a VC means a DB matter is there from principal seat.
Your Honor may kindly take it up tomorrow.
Tomorrow can it be?
Obliged.
My lord, I'd like to mention item number 2.
Hmm. What happened?
Today I am filing one IA for condonation, so
Earlier it was not filed.
not filed. Today I am filing. I need 1 week time.
Your good name?
T. Torum.
Had Mr. Peter the London Council for the petition. It is submitted that one interlocutory application for condonation delay has already been filed. So bid to tag the present petition along with the interlocutory application for condonation. Raised it accordingly directed to list the present petition along with the I after 2 weeks.
Obliged.
Yes, Your Lordship, this is a petition under 482 of the CRPC, praying for quashing and setting aside of Teju PS case number 76, 2016, under section 465, 420 IPC. Basically, the point which is raised in this petition is under 195 CRPC, which speaks about the bar of taking cognizance by the court is involved. That is what the issue. Now, here, the allegation here is that the opposite parties, respondents, Your Lordship, the private respondents had filed an FIR before the officer in charge of Teju police station, inter alia alleging that, Your Lordship, that the present petitioner had obtained a decree. This is the allegation. Obtained a decree from the district judge, Honorable District Judge at Teju, by means of producing fraud documents, fraudulent documents. This is the allegation made by the defendants, the respondents, present respondents, Your Honor. And accordingly, he had obtained the decree. Now, on the basis of this FIR, the police had registered the case. And this is how I have come up before this honorable court, because allegation here is basically a forgery which has been played upon the court. This is the allegation, Your Honor. Now, law is very clear that whenever an allegation of forgery is made against a court, 195 clearly says that that has to be filed by the court concerned or by any other officer duly authorized by the concerned court or by any subordinate officer to the court in which the forced document has been produced. Your Honor. But then since there is a specific bar under section 195 CRPC, despite of that, the police had registered the case and then investigated. Now, at the time of filing, Your Lordship, now there is a subsequent development. We were unaware at the time of filing. Now, subsequently, during pendency of this application, I have come to learn that the case has been turned into final report, Your Lordship. Final report has been filed, so no point of further proceeding with this case. I'm just submitting about the facts of this case. Now, this has become, in that manner, this has become infructuous because FR has been filed. Your Honor. Final report has been filed. Now, of course, that has not been considered by the court, but then FR has been filed. Subsequently, I have learned it. Your Honor.
Already FIR.
FR, final closure report of the case has been filed, saying that this is a false case. So having said this, since this petition has become infructuous, Your Lordship, and considering my submissions, this petition may be disposed of, saying that if the FR is filed, that may be disposed in terms of the law and the submissions made by me, Your Lordship. This is all.
Yes, Your Lordship.
Heard Mr. C.W. Martin.
Yes, Your Lord.
Counsel for petition, also heard MS TGB, the Daniel additional PP, appearing in of state respondent. This is an application on section so and so for washing. The FIR dated so and so, registered under section so and so, under Teju police station case number. It is submitted by the London Council for the petitioner that the case was filed by the respondent alleging that the present petitioner has obtained a decree by producing some forged. The documents were forged, which were produced.
Allegedly,
Allegedly forged documents before the court of
District
District Judge.
District Judge at Teju.
District Judge Teju. But District Teju, without violating the mandate of section 195, 1B, small b, and bracket of month of CRPC. Post of, however, it is submitted to the London Council for the petitioner that as per the recent development, the FR has been submitted by the I in connection with this case. With the observation, you have not filed the copy of the FR, no?
The FR copy has, it has not been filed because at the relevant time, I was not aware of this fact. Subsequently, I have learned, Your Lordship, that FR has been filed. Yes.
That FR has already been filed in connection with this case. With an observation by the IO that the false case was honest, false FR was not very influenced. In view of filing of the FR or closure report of by the prosecution, it is submitted that the matter has already become infructuous and accordingly break to disposition. Considering the submission made by the London Council for the petitioner, it seems that the filing of the FR, the present petition is becoming infructuous and accordingly disposal has become.
Yes. Your Lordship, one line may be kindly made. The learned magistrate consent shall consider the FR as per the relevant provisions of law, Your Lordship.
That too subsequently, it will be, once the FIR is placed before your Lordship, the honorable court during the CC, it will be done according to the
Your
law.
Lordship,
There not need to be any,
That is, we are not seeing anything. We say as per law, Your Lordship, as per law. That line should be made.
they're not, since it's just been placed there, the cognizance has not been taken yet by the court, your Lordship. As per the law, it will certainly be.
Otherwise, it may be, the court may, the concerned court or concerned may still may think that maybe a direction or whatever.
Yes,
So
yes. Yes.
All right.
Deeply.
Obliged, Lord.
Why not live streaming? Maybe live streaming may not. It's a 376 matter.
Your Lordship, this is a 482 petition whereby AU PS case number 103/2014 has been challenged. Now, the present case has been filed into charge sheet, which is at the very nascent stage of the trial.
This is already charged.
This has been charge sheeted and at the very nascent stage of the trial, no charge has been framed yet. Now, Your Lordship, here basically this application is filed on the basis of settlement having been arrived at between the parties, Your Lordship.
But
Now-
whether the petition would be. Is it a
This-
joint petition?
This is a joint petition filed by the accused as well as by the informant. Your Lordship. At page number 45, annexus 7 is the deed of settlement. This is the deed of settlement. Before, Your Lordship,
Settlement took place when?
settlement took place, this has been executed, Your Lordship, very recently on 25th of May 2023 at Highland, Your Lordship.
The FIR is updated.
FIR is of 2014 and the date of occurrence is 2012. Your Lordship. After 2 years, the FIR has been filed.
Date of occurrence is 2012.
FIR is 2012. Oh, the FIR is 2000, date of occurrence is 2012. Alleged allegations. Now, FIR has been filed in the year 2014.
FIR is filed in 2014,
14. Allegation is of 2012, Your Lordship.
after 2 years.
2 years. Your Lordship. Now, here, Your Honor, before coming to this deed of settlement, I would like to just separate this quote in a nutshell, Your Lordship. Here, basically, there was an agreement between the parties, the petitioners. There was an agreement between them. No other person is involved in this case, only between the present petitioners, Your Lordship. There are 2 petitioners in this case. Now, here petitioner number 2, the informant, Your Lordship. The petitioner number 2, allegation is that he had paid an amount of rupees 18,000 to him, rupees 18,000, way back in the year 2018. On the agreement between both of them that the petitioner number 2 shall provide him a job. This is the agreement between them only. Now, since the petitioner number 1 had failed to provide him with the job, instead of providing him with the job, he says that petitioner number 2 says that instead of providing me with a job as agreed by the petitioner number 1, she had issued me with a certificate. She had issued me with a certificate which is said to be forged also, a class 10 pass certificate. Now, subsequently thereafter, after 2-3 months, in the year 2014, he's lodged his FIR. Date of occurrence is 2014. And after lodging of the FIR, thereafter, after 2-3 months, Your Lordship, the petitioner number 2 informant had taken an amount of rupees 50,000 from her. And he had filed an application saying that I'm not interested in the case before the police station and as well as before the magistrate, saying that I have got the money which I have paid to her. Your Lordship. Now, even otherwise, section 460 prima facie not uttered. If at all, there must be a legal injury, Your Lordship, legal injury. That very document was never used at any place for any purpose. That was an agreement between 2 persons. In fact, here informant number 1 should, informant number 2.
He procured the false matriculation certificate.
It is the allegation that the petitioner number 1 had prepared it and given it to him instead of giving him with the job. But then that very document, which is alleged to have been forged, that has not been used in any other office, any other platform or any other authority, Your Lordship. If at all the allegation, there has to be legal injury. Your Lordship. For the purpose of attracting forgery, Your Lordship, there has to be a legal injury, legal injury. That forgery has to be with the purpose of causing legal injury. Now, the definition of legal injury is very clear. That goes without saying as to legal injury means wherein the person who had sustained the injury must have the legal right to enforce the remedies which is available to him due to the injury caused to him. Black's Law Dictionary clearly defines it, Your Lordship. This is the definition of injury as defined under the Black's Law Dictionary. Now, If at all, your lordship, if at all, it should have been a case of cheating between them, your lordship. No third person is involved, no further act is there, no overt act is there, your lordship. If at all, it should have been a case of cheating between them, your lordship. 415, punishable under 417, your lordship, which is a compoundable offense. Now, both the parties have in the meantime settled it, and the FIR has been filed belatedly. The main purpose was to, of course, this is a case which is clubbed with a civil flavor, in fact, which is, of course, even otherwise not enforceable in law between them. So this is the case. The parties have amicably settled the matter, and he has received the money of rupees 15,000 plus interest of rupees 32,000 interest he had received. So at this stage, the case is also at the very national stage of CC. The charge has not been framed as in the lordship. So on the basis of the joint petition filed by the informant as well as the accused, lordship, I pray before this honorable court to allow this condition in view of the settlement having been arrived at between the parties, lordship, in terms of 482. Even if there was forgeries, prima facie is not there. It's forgery, your lordship.
May it please your lordship. Since your lordship, they have approached it was squarely on the basis of settlement, your lordship, squarely on the basis of settlement, not on the merit of the case, whether the section is attracted or not. So now at this stage, your lordship, so far as the fact is concerned, no doubt, your lordship, the document whichever has been alleged to be manufactured, it was not produced before any other authority. It was between them, your lordship. And for manufacturing the document, so far as the FIR is concerned, the amount has been taken for providing a job. But the accused has somehow manufactured a document of class, perhaps it's for class 10, your lordship. And so far as your lordship, the ingredient for attracting section of forgery is concerned, your lordship, what Honorable Supreme Court says, your lordship, the definition of offense of forgery declared the offense to be completed when a false document or false part of a document is made with a specific intention, your lordship. The questions are, is a document false first? Second, is it made by an accused, whether it was a manufacturer accused, and is it made with an intent to defraud? It doesn't mean it has to be produced before any other authority. By manufacturing document, he is obtaining something from that person. Also in that case, the section will attract. So he has taken 18,000 out of it by doing so. But no doubt, so far as the agreement is concerned, your lordship, he has been compensated, your lordship. As per the agreement, he has already paid 50,000 something, your lordship, in return of that. However, your lordship, the document was in between them only. It was not produced before any other authority. So now, since they have settled the matter, your lordship, so whether, your lordship, under invoking the parameter laid down by the Honorable Supreme Court in Lakshmi Narayan, whether it will be attract or not, your lordship, and whether it will be favorable case will come under the purview, your lordship. That aspect I will leave it to your lordship discretion, your lordship.
Yeah, adding to this, Bhajan Lal's case guidelines, which is the landmark case regarding 480 to be invoked by the Honorable High Court throughout the country. That has been very elaborately laid down by the Honorable Supreme Court in the case of Bhajan Lal. When the case is predominantly of a civil nature, and the court, the High Court would be well within its jurisdiction to exercise 482.
Can you say it's a case of civil in nature by forging a document?
Your lordship,
Whatever, it may not be produced before any authority concerned,
yes,
but still, a matriculation certificate has been manufactured or it has been forged.
it is.
In that case, whether it comes under the purview of civil matters.
Your
Can it
lordship,
be-
in that, your lordship, in that situation, in that situation, your lordship, no any remedy is available to the parties in that situation, because he is a party to the contract which is illegal, lordship, even otherwise. He is a party to the case which is an illegal agreement, and settled law, illegal agreement is not enforceable by lawyers. That is what, your lordship. And then one submission, last submission, the case is at the stage of CC, your lordship, at this stage.
The agreement itself is illegal.
That is illegal, void agreement, your lordship. That is a void
There
agreement.
cannot be any.
And there has to be an injury has to be a legal injury. And if at all, your lordship, here the accused should have been the informant only because he has paid the money, He has paid the money to him. This is an agreement between two persons, A and B. No third person is involved. So this case. It may sound to be very serious in nature, like a job scam case, Your Lordship. But then this is not the case in that manner. This is an agreement between two persons. Your Lordship, this
Make it seem because other works are there also.
is all.
Yes, oblige. Your Lordship.
Application in connection with Chimpu case number 22 of 2025 under section 21B and 27A and DP Sec Lordship. FIN page number 14. May I read, Lordship? It is informed you that today 1/5/2023 at 1300 hours information was received from sources that one person, namely Rohit Bosumotari, this is the accused petitioner, Lordship, so and so Assam has been selling contraband substance heroin in the jurisdiction of Chimpu PS. On receipt of aforesaid information, intimation was made SP City. Accordingly, undersigned along with the police team located the said wanted persons and found at near place Takum Hapa at around 1350 hours. During house search, a suspected contraband substance likely to be heroin was found in his possession. Accordingly, the undersigned and team of police visited the place of occurrence for search and seizure. The suspected contraband drugs were weighted with the weighting machines available with the team and found to be weighting 14 grams with plastic pounds and 10 grams without pounds, Lordship. Today is the date for 90 days behind the bar, Lordship, and 10 grams of suspected of heroin was recovered, and moreover 16,000 of rupees was seized by the investigating officer during the term of investigation, Lordship, from the accused petitioner. That's why the 27A was annexed by the investigating officer in this case, Lordship. Moreover, the section is intermediate quantity.
Since when he is in custody?
2/5/2023, Lordship. Today is 90 days, Lordship. Update she was calling for.
But in regards to 27A.
Yes, Lordship.
What do you want to say?
27A, Lordship.
Also incorporated most probably.
Yes, Lordship.
What was the amount recovered?
Amount 10 grams, Lordship. The amount of
No,
money is 16,000 only.
Well,
16,000.
money.
16,000.
You have received the CD. Okay.
Lordship, we have received the CD, Lordship, and Lordship, in CD, Lordship, the accused statement, it is reflected that Lordship, Lordship, the selling, Lordship, that's his statement, as per statement, he is not addicted, but Lordship, then Lordship, that 27 is not attracted, but 27A may be attracted, Lordship. Because as per 27A, Lordship, may see, Lordship, 27A.
27 doesn't matter. 27A is, he is not addicted. He was most probably.
Lordship, 27A is Lordship included in this.
27A, I am on 27A.
Lordship.
Yes.
As for 27A, Lordship, it is punishment financing illicit trafficking and harboring offenders. As per this, Lordship, whoever indulges in financing directly or indirectly any of the activities specified in section 2 of harbors, any person engaged any of the aforementioned activities shall be punished within the rigorous imprisonment for not less than 10 years, but extend to 20 years, Lordship. Lordship, as per the accused statement, Lordship may say the statement.
What is submission?
Lordship. As per his statement, Lordship, he revealed that he is not addicted to the illegal substances, but openly spoke to that he is not a consumer, but after all, he is selling the illegal contraband substances. Heroin at Eternal Capital City after being bought from Nagaland border area, Dimapur, and destroying and deteriorating the teenagers and young youths, as well as the hopeful guardians of the teenagers youth who wanted their children to acquire a successful path, but being declined due to such type of illegal miscreants. So this is Lordship very serious offense, Lordship. And Lordship, as per Lordship, as per 27A, if it attracts Lordship, then it this punishment is extended to 20 years, Lordship. The 180 days can be Lordship. He may be kept in the custody, Lordship. And Lordship, here Lordship, this CD, Lordship, I'm very sorry to Lordship, submitting that indeed this CD also, this, statement of witness is not Lordship, annex Lordship, today also Lordship. I don't know why Lordship. I spoke to the IO of this matter, Lordship, that why you always send the incomplete CD, because statement of the witness may be needed, whether to Lordship see this accused statement is collaborating or not, Lordship.
It was returned on 26.
Lordship. So Lordship, I am like submitting that next that Lordship, IO maybe call for Lordship.
Or you have come to Guwahati.
Yes, Lord, I'm coming to Guwahati.
Guwahati. You can make the conflict with, by tomorrow it can be, it can.
Lordship. Then Lordship, IO maybe call for Lordship, because I'm also Lordship very much.
Today,
Lordship.
second day, Lordship.
That's why
Thursday,
Lordship.
we strictly instructed the IO to produce the update CD, Lordship. If they have fall, then
27A, for a practice, whatever for 27A, the witnesses has to be recorded.
That's why Lordship.
How can you gather any information? That
That's why Lordship, that's why Lordship.
What is the?
Lordship, see Lordship, here Lordship,
I have
it is, yes, Lordship, here it is Lordship reflected that statement of witnesses also recorded Lordship. It is recorded Lordship, it is
But not
reflected
enforced.
in the month of 2nd of May, but till now they have not ended the statement of the witness.
Heard Mr. G. Kupan, the learned counsel for the petition, and also heard MSI Hagi, the learned additional VP, appearing on the court state respondent. CD received, but it is surprising that CD do not contain the statements of the witnesses too. It is stated to be recorded, to have been recorded on 5th May.
On Lordship, yes, Lordship, 2nd of May, Lordship.
2nd of May. The I will, the proposed notice will be issued to the I as to why he has not annexed the statement of the witnesses in spite of repeated reminders. The copy of order be sent to the I and the learned said we will make necessary necessary correspondence with the I. So that the CD may be reached by the Wednesday, can be reached
Lordship,
from where? It
from
has to
this
come.
Itanagar, Lordship.
in the capital, Vitanagar. also.
The matter be fixed up with the Wednesday is 2nd August.
No, Lordship, I mean, I'm not available. After 5, I may be available.
After 5 only,
5 August.
5 August.
Yes.
Then if it is Lordship, it is.
In the meantime, Lordship, Mayor submission in the meantime, show cause of notice issued to the IO, Lordship. In the meantime, this honorable court may grant interim bail to the accused person.
No, no,
Pursue
Lordship.
the this condition as required to the court. There is no bar, Lordships.
Finally dispose of the matter,
Okay.
but tomorrow you are here.
No, Lordship. I have
Tomorrow
to
you are
return,
here.
Lordship.
I have no problem, Lordship, submitting tomorrow also, Lordship.
If you can stay back to tomorrow, then. you
No,
can-
no, Lordship, no.
Then Lordship, if the after 5, then Lordship.
Okay, I will manage one day, Lordship, tomorrow.
Tomorrow. Can it be possible tomorrow?
Lordship.
You will address the copy, send back the copy, CD, and with the direction to send the
Statement of-
statement of the witnesses along with this diary.
Then IO need not be called for Lordship, then only Lordship is directed to call the IO in person, Lordship, or just.
Directed to call the IO in a sense, we need the CD also. He may present along with the all this copies and all. We may be confirming the requirement with him.
Lordship. Obliged, Lordship.
Then tomorrow can be fixed.
I'll manage. Unless.
Then tomorrow after 2, Lordship, because maybe this morning time, it may be difficult, Lordship. Obliged, Lordship.
We please the lordship. The earlier occasion step was taken according to the order of this honorable court, but
But
Yet,
what is the position now? It is not served.
notice, I saw, I took step,
No, you
But-
took state,
uh,
but notice is not yet served. It is only the sole respondent.
yes. Sole respondent, both items are analogous. So I may be allowed to take first step for the last time by Dusty and other Way of,
Mr. Yudhaka Dilani put 7 and 8 same order. Yudhaka Dilani counsel for the appellate. And it is submitted that he already took steps on so responsible, but it is, but as part of this, no service report on, service report on, so respondent is still awaited. Let fresh steps be taken to the sole respondent to register it as well, and justice services also allowed. Needs the matter accordingly after, it will take
4 weeks,
4 weeks.
won't
will be
delay,
registered.
Your Honor.
The
Lordship.
matter will register.
Obliged.
Excuse me, Your Lordship, no, I think 14.
1/4. Ah. Yes, still awaited.
Still awaited, Your Lordship.
For whom?
Respond,
Private response.
respondent number 4 to 9, Your Lordship.
So it can be awaited for one more date.
Yes, Your Lordship. Or otherwise, direct them to take fresh steps, Your Lordship.
Awaited.
Awaited, Your Lordship.
14 of awaited for the private respondent. Hard so and so, I mean, hard, so and so. Let the, the.
4 to 9, Your Lordship. 4 to 9.
Private respondent from 4 to 9 is awaited, list the matter accordingly after. Let it be after 2 weeks only, because if after 2 weeks also we do not receive any notice, then obviously it takes. No, this time we are not going to take, we are going to await for last 2 weeks. 2 weeks we are going to await, and after 2 weeks, if it doesn't work, then definitely will place steps. After 2 weeks. Pardon? Interim was there. 2 weeks. Interim be continued till next step.
Obliged, Your Lordship.
At 2, I'm having a DV from principal 6, so I may be 15-20 minutes late. Two, I'm having a DV.
And thereafter your lordship, thereafter your lordship will see.
Yes, I will receive, but it may take some time, 15-20 minutes.
As per section 100 of CPC. After formulating the substantial question flow, then respondents are called to argue on that point.
But the process has been, or notice has been issued without framing the substantial question of.
Yes, in the past stage, it was notice was issued.
But whatever, but notice has already been issued. Now, what is the service condition? It's still awaited.
Madam,
Service is still awaited.
awaited. So meantime, substantial question can be formulated. Then, as and when they appear,
In general, substantial question of.
law is to be past
okay,
formulated.
should be formulated, then only the appeal can be. admitted.
Yes, this is the procedure.
We will. In the meantime,
LCR is also not called.
Hmm?
LCR is also to be called. Madam.
Esther will call for again first to whether it will be admitted or not. that we
Yes.
see.
Yes.
So where in the, which you have formulated separately here, substantial question of law are already been formulated by you,
Yes. It is a case, my lord, 13,
page
13 madam.
1-3.
Yes, ma'am.
These are the substantial. questions.
Yes, my these are the substantial.
You will hear the matter then.
Okay.
Let us see on the next day. Heard. Mr. K. Tani.
Yes, ma'am.
Land counsel for the appellant. The notice on the sole respondent is still awaited. However, it is seen that there is no the substantial question of a law are not yet formulated by this court. So the notice was already issued on this phone number, sole respondent. Notice the service is still awaited. In the meantime, on the next stage, there will be hearing on the substantial question of law under order 41 on that.
Yes, no.
Or
Section
43.
Section 100, section 100.
Section
100.
No, I
Oh,
think it's
yes.
filed by you on 100.
Okay, okay.
That's substantial question. I'm confused. Let the matter be listed. SD, we have to await for the service of notice. So when you have taken steps for the notice?
Steps was taken, so my look. 24th or 25th, my lord, step was taken.
24. Most probably on 29/6, so it can be awaited for 2 weeks minimum.
Okay, no, 2 weeks.
Let needs to be listed after, on that day, your substantial question of law hearing on that point will be there.
Okay, okay, okay.
Yes,
Service report is still away
form for whom?
for a sole respondent.
For sole respondent.
Yes.
So you can await for another 2 weeks.
2 weeks, yes.
Your Mr.
B pardon.
Mr. B. Dalu, the Dalu Council for the petition. As per office note dated 29/7/2023, the service is still awaited for the sole respondent. Let the matter be accordingly listed after 2 weeks.
God bless.
This is a jail appeal.
It is a jail appeal.
Yes.
Uh,
may be appointed.
already appointed.
No, not appointed. This put up first then.
Procedure, as per just I'm asking you, as per procedure, the amicus is appointed. So he will file the appeal memo or who will draft the appeal memo? Because it is the office note only. As per the, except the office note, there is nothing. It's the office note from the register. So we can direct the amicus to prepare the appeal memo also. Because there is nothing. It's a jail appeal, I can understand.
Jail appeal.
Yes, but still one appeal memo should be there on the 2-3 grounds or whatever. It's a very simple appeal memo. That can be done by the amicus also.
Yes.
Yes,
Mm.
and then you can call for the LCR also by this time.
Yes.
And there are so private respondents will also be there, I think. It is a case under which section?
It's a POCSO.
So victim or informant, whoever, he or she has to be made a party. Or notice has to go there.
Notice has to be given.
Mr. G. Dalu, the learned additional PP appearing on behalf of state respondent. This is a jail appeal. And accordingly, I find it justified to appoint an amicus curiae. So prepare the appeal memo accordingly. To prepare the appeal memo accordingly. Also call for the LCR. The registry will be in appointing the amicus curiae in this case. Let the matter be accordingly, also call for the LCR, let the matter be accordingly listed after 4 weeks. It will be listed after 4 weeks and after the appeal moment, then we'll send the notice to the respondent also.
Okay.
After 4 weeks.
It's also a jail.
It is also same, same
Jail.
order.
Same order.
Already the other side has already been appeared, I think.
Yes, I'm appearing on behalf of N Sharma. His
On behalf of,
service has been completed with regards to all the packages.
no, the service is already completed.
Yes.
Okay. So you are appearing for respondent
I'm appearing for petitioner on behalf of N.
and Sharma.
Yes.
And the state is also there and
I'm for respondent number 226.
2 to 6, all respondents
All
are.
the respondents. Private.
You, so matter can be,
Well, hearing was it?
is there any or
Because this order stays today. So if service is completed, then it's maybe it's for, otherwise admission, maybe listed in admission.
It can be for admission hearing also.
Yes, yes.
Admission hearing stage, it can be disposed of if it is possible. Because most probably you are not ready.
Yes.
I think so. And Sharma is not available.
No.
Let us accommodate him.
Myself.
And your good name?
B partner.
Huh?
B partner.
Had Mr. So and so appearing on behalf of NPS Council, Mr. N Sharma for the petition. Also had Mr. K. Buri, the Learned Council appearing on behalf of the private respondents. And also heard Ms. MS L. Hage, the Learned Additional VP appearing on behalf of state respondent. Service is already completed. And let the matter be accordingly listed for admission hearing after 3 weeks. 3 weeks will do. Is there any problem?
No.
Or you wanted date fix because he has to come from Guwahati or he's from here only? Better to take a date fix?
No, there is no any such instruction.
No, I'm not on that. He hails from this place or he hails from Assam or Guwahati? Guwahati, that's why I'm asking to make it convenient for you only.
My lord, in my case also, the leading council is from Guwahati. So may I just pray for them? 11th September.
11th September, we are fixing on 11th September, you just take this. 11/9.
11th. Online.
Yeah. May I proceed?
Yeah,
Lordship,
service is completed?
Yes, service is complete and respondent
Appear already.
4 and 5 appear.
No, your lordship, I'm having only for 4.
You are only for 4. 5,
5, not, service not completed. As per office note.
what to do in absence of 5, can it be proceeded or 5 is unnecessary?
No, it's necessary party.
But these 4 and 5 are same person, not exactly same person, but they are the complainant informant.
Both of them are
Yes,
complainant?
both are having same interest. 4 and 5.
Both of them are complainant?
Yes.
Actually, your lordship, actually in this case, there were 2 FIRs.
Oh, 2 efforts.
Okay, one FIR was lodged by me, that's called respondent number 4. However, the second FIR was lodged by private respondent number 5. And the
In that case, most probably 5.
5 is required, your lordship.
Necessary party.
Is a necessary party.
Should be necessary.
Yes, yes.
Suppose if the FIR, suppose it is lodged by or signed by 2 of them together, that would be different, but 2 FIR has been lodged. right?
Yes.
So in that case, why it has not been served? Is there any office note? Service report, AD card.
In that case, I may be allowed to serve the service by Dusty.
See, we are praying for Dusty and all, but these are the criminal matter section.
This is a
So
criminal
they
case.
cannot say
That's
Dusty is allowed.
jurisdiction process.
And other was, what type of, what kind of thing was there?
But
Took the steps through which mode?
Yeah.
Register AD. Earlier.
yes, earlier yesterday.
So this time, let us see through jurisdictional police station, if FIR in address is proper in the FIR,
Yes.
then it will go.
But in this case, Lord, see what happened, the case is registered on the strength of the FIR dated 12/12/2021. Filed by respondent number 4, not by 5.
So it's up to you then. You do not want. If you are saying that 5 is not necessary party, but otherwise 5 is necessary party because
Yes.
most probably otherwise it will be because you are against 2 FIRs.
Yes,
Lost by these 2 complaints.
yes.
That is there. Third, Mr. S. Your Mr.
R. Emo.
Mr. Arifu, the Learned Council for the petition.
Lordship, I have interim. So my interim prayer may be allowed. considered.
Earlier also you were in injury.
No, the interim prayer was supposed to be considered today, sir. As per order dated 27/6/2023.
Your lordship, however, that was subject to the completion of the service. I think so. That his interim prayer will be considered. However, with regard to his interim prayer, your lordship, I have an objection. In this case. I'm seeking this honorable courts.
So what is the?
We have already received LCR. So, matter may be proceed as,
So you raise an objection that 5 is not yet completed. that is-
yes. Interim may not be allowed this time.
Now you are raising 2 issue, LCR is there. You are ready to hear, but 5 is not there, so
Yes,
what to do?
we have to, we need to complete service upon 5.
Then. So he is insisting for interim, I don't know whether it can be allowed or not, but most probably as per order, last order.
That
last 2
Proce-
consecutive orders.
Proceeding may be continued before trial court.
If proceeding is continued, then there will be no interim.
Yes,
Then he is insisting for interim. At what stage the case will be?
appearance on 22nd of August.
Both cases are on the appearance stage only. Then what is the issue?
Lordship, trial has already commenced.
What charge has already been
Yes.
framed?
No, charges to be yet to be framed.
Then what the trial is commenced? Trial is not yet commenced.
Yeah, someone for appearance on 22nd.
Yes, that is one.
So,
And you can, you are on bail. You are on bail, isn't it? So you can appear also, it doesn't matter.
in this case, by interim prayer may be allowed.
Yes, put the objection.
Lordship, service with regard to 5 may be evaded because there are certain facts wherein certain facts of both the affairs are different, your lordship. Because my
In that
contention,
case, against the interim also you want to file an objection.
yes, your lordship.
So in that case, we hear the better to hear the entire matter only. Hearing the objection on interim, you can hear the matter, entire matter. But subject to question is that the I mean, service is not yet completed on respond number 5.
Yeah.
So that may be the one issue, otherwise, so. Heard Mr. So and so, and also heard Mr. Jitan, the learned additional PP, and your good name was?
T Sering, your lordship.
And also had Mr. T. Sering, the learned counsel, appearing on behalf of respondent number 4. And you are appearing for 1, 2, 3.
Yes.
For 1, 2, 3. Respondent number 4. However, it is from the official dated 28/7/2023. The service report, neither the service report nor the AD card for respondent number 5 is received back by the registry of the consent section. In that regard, the learned counsel for the petition, we have asked to take steps on respondent number 4, 5 through OC of the consent police station or through jurisdiction police station. Further,
Or through the still. No,
still,
that-
so it is
that's still-
actually
will
that's
not
still
allow.
allowing, I don't know why it is that criminal matters. Anyway,
Counsel,
counsel, next
okay.
next para.
Intimidate
Further,
them.
it is submitted further, the learned counsel for the petition also stress on the interim relief, interim prayer. And pray to stop the proceeding of the connected criminal matters. The learned counsel, Mr. T. Sering, appearing on behalf of respondent number 4. And also the additional PP raised objection and it is submitted that he wants to file a written objection against the interim prayer. It is seen that LCA has already been received and hence let the matter be listed after 3 weeks. And let the matter be listed after 4 weeks and in the meantime, the learned counsel for the respondent number 4 is at liberty to file or written objection, if any, against the interim prayer. However, the endeavor will be made to dispose of the entire matter as the LCA has already been received. Let the matter be accordingly listed after 4 weeks.
Much obliged.
Your lordship, sorry for interruption. It is not against
Objection is not against the interim bail. It's against the proceeding.
No, no, it's against the interim.
Interim is not against the bail. Objection against interim is not against the bail. It's against the proceeding. I suppose I had,
If you suppose you have any objection regarding the interim for what? To stop proceeding. As per them, proceeding should not be initiated and it should be stopped or it should be.
yes,
That is the main prayer for interim. So he is raising the question that it should not be stopped, proceeding should be continued.
yes.
And in that regard, I am submitting that you also have an objection is to stop the proceeding. Isn't it? So that's-
In that case, Lordship may kindly fix the matter before 22 August.
22 hours.
Yes, 22 August, 22nd.
22 August.
Yes,
Acha. Okay. 22 August,
yes, before 22 August.
you have an
Yes.
issue otherwise.
Since I have to appear before the learner court below on 22nd
You will try
August.
to.
Otherwise, your Lordship may kindly allow the interim prayer till returnable date.
22 August won't be for 4 weeks, I think.
Yes.
So. I don't think. So.
Otherwise, Lordship may kindly allow the interim prayer.
After 4 weeks.
Obliged.
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 Please, my lord, this AB 45, this is connection with the Talia PS.
From this one.
This is in connection with Talia PS number 4 of 23, my lord. And on 27/7, my lord, last Thursday, my lord. Two other AB were heard by your lordship.
By two brothers.
Yes, the two brothers, yes. And it is AB number 43 and 44, my lord. This is. This is 40.
Interim was there.
Interim was there. In the 43 and 44, it was the sons, and today it's the father, my lord. Your lordship has already granted interim protection to enable the applicants in AB number 43 and 44 to appear before the IO. So may I pray, my lord?
He is the father today.
Yes, today is the father, my lord. So may I pray, my lord,
That day
similar?
we inquire, where is the father?
Yes.
Saying the father is.
Yes, yes. Father was not there on that day. Yes. So all the matter may be taken up together on 9th itself, your lordship.
So this passed in.
Yes, on parity only, your lordship. However, your lordship.
You have who took dictation for these two? You have not taken it.
No, it was
For the Kappa only before, sooner.
other vote, just my lord. So.
Maybe 40. Who were there? Two
Two,
brothers
yes,
were there.
43 and 44.
43 and 40. On 27/7. 27/7. On 27th of July. Find them.
Yes,
We will pass the order.
Yes,
And
yes, sir.
the date was, which was the date?
9th.
9th of August.
August. Here also, your lordship may give a direction to appear before the IO, your lordship.
Yes, yes, I
Yes,
have
yes. Deeply obliged.
So, really Yama took the dictation. And father to change the otherwise all the same, more or the same.
Yes.
And we put a date on 9th of August.
Yes, yes.
Give this one.
Deeply
Okay,
obliged.
will be on 9th of August.
Deeply obliged.
Lordship, in item number 10 and 13, I forgot to make a prayer for continuation of the interim order.
10 and
13, 1-3. There is an
you
error.
were interim orders.
Yes, already drafted.
You took the dictation, 10 and 13. Muni? Okay, for both, in both the cases, you submitted interim, we continue till next.
Yes,
Both 10 and 13.
10 and 13. Obliged.
Yeah, 17.
May please, your lordship. My lord, in this case, I have for coming for under 482 for quashing of the complaint, my lord. For taking the cognizance under 420. My lord, my respectful submission would be on the 3 points, my lord. First is the suppression of facts.
Suppression of
Facts. Second will be, my lord, it is a civil nature and they have used the, they have taken the CPC procedure, CRPC procedure, and third, under 202 of the CRPC. Because the accused is outside the jurisdiction, he is in Calcutta. So that procedure has not been followed. So on the first point, my lord, for suppression of facts. Before that, I would like to submit that your lordship, the respondent is Jotam Togo Takam. While this proceeding was going on, he expired, and in his place, his legal heirs have been impleted. My lord. Okay, my lord, that is the.
What's the respondent number?
That is, they can say, what the respondent, they have not made them party also. One is,
Respondent one, he was respondent one.
he died.
So he died.
And court, by virtue of the CPC, the court has made them party, the legal heirs, they have filed the petition to be impleted, that is by court's order, they are impleted, my lord. That we important. Now, lord, my lord, before I proceed to the case, my lord, I would like to take the suppression of facts first, because it is a settled law that whoever comes in the court, he must come with a clean hand by narrating every facts. Now, if your lordship takes my affidavit in opposition, no, affidavit in reply, that is, your lordship will file lordship will come page 7.
7 or?
6, page 7 of my affidavit in reply, madam. Paging was not done. That is affidavit in reply, lordship.
Yes, page 7.
Page 7 in affidavit in reply, that is the power of attorney. The lordship got it? My lord, I just say, I'll go through the content of the power of attorney. I see Kanhailal, whereas I see Kanhailal, son of late Nani Gopal Mukherjee, residing at EO so and so at Jadavpur, Calcutta, has been carrying on the business of civil contractor at above mentioned address under the name and style of KLM Enterprise. As a sole proprietor having office and the said business concerned Navagraha Post Office so and so, Calcutta. Whereas I have been in favor, your lordship may know this because dispute arises from here. Whereas I have been favored with the job by the executive engineer, Tezpur Central Division, PWD Tezpur, for construction of Johar Navodaya Vidyalaya with 3 nodes of dormitories. This is very important, your lordship may note this, and so and so. Now, my lord, next time coming, whereas the other additional assignment we are of the opinion of taking additional hand with facilitation for completion of the assigned work and the stick endorsed to the stipulated terms. Whereas I see Toko Tagam, that is the respondent herein, and he is the complainant at that time. Son of late Togo Handa, so and so, who is known to me and whom I confident, particularly because of his integrity of character and being conversant with the nature of the job. Whereas it is being here explicitly made clear that the power of attorney is solely confined to the job. This is the very important, your lordship will know this. Job known as Johar Navodaya Vidyalaya with 3 dormitories, 2 for boys, 1 for girls, and 6 warden residents, including the internal water supply, similar installment, so and so. Now, my lord, next your lordship will come to the relevant portion. I, J. Toko Takam, being authorized and empowered to do act, deed, and thing in relation to other job of mine with the said department or any other department at all. Now, my lord, now therefore known to all that present I see Kanhailal, son of so and so, do hereby appoint, nominate, and constitute J. Tagam, son of so and so, to be my lawful attorney, to act in my name on my behalf, to do all the acts or things connected with the job assigned by the executive engineer Tezpur for so and so that purpose. Then your lordship will come, next page, 129, my lord. To negotiate with the concerned department in respect of execution of job, to enter into correspondence with the department, to receive letter, to sign all bill, papers, documents regarding the assigned job, to submit bills. Your lordship will take this. Submit bills, paper, documents concerning the assigned job, to sign and submit the progress report so and so, to offer, arrange for inspection of the site and the process of the assigned job to the concerned department of their authorized man and result. Now, my lord, this point 8, to receive money in cash, check, draft, and any other order falling due and payable to me for assigned job of being carried under the name and style of KLM Enterprise, and to grant the receipt thereof for acknowledgement, to deposit the security money and other conditions are there. Now, my lord, by this power of attorney, he is representing me in Arunachal. I am at Calcutta, and I have authorized him to do all the function to take the loan, whatever he wants. Now, your lordship will come to the complaint petition, my lord, which I am asserting is suppression of or suppression of facts. My lord, if your lordship goes through here, will not find a single word that he is my power of attorney holder. Not a single word he has given here that I am his power of attorney holder. What he has stated here, your lordship will come, para 3 onwards, my lord.
Page number.
Page number 11, my lord. Para 3 onwards. He has admitted that I had a business relation with him. Para 2 onwards, my lord. The accused number 1 and 2. The accused number 1 and 2 are non-indigenous people of Arunachal Pradesh and belong to the state of West Bengal, having permanent residence in Calcutta. The accused are the businessmen in profession, and in the year 2008 and 11, they run their business in the state of Arunachal, particularly usually KGNB compound under the lower Subansiri district, Arunachal Pradesh. That the humble complaint begged to state and submit that the brief facts of the case is that the complainant and the accused have known to each other for long years. As a businessman, during the year 2008, the complainant was the member of the Legislative Assembly of the 16th Mutual Constitution under his jurisdiction. The accused person were executing the work in Jawaharlal Nehru Milot Kendriya Vidyalaya compound and approached for financial help. Here your lordship will take the note. Financial help in order to complete the ongoing construction work, and or reply with their work project. Complainant was lent a sum of rupees 75 lakhs to the accused person in a returnable basis by executing deed of agreement on 2/4/2008. Now, your lordship, I will come to that agreement later. My lord, here in this petition, he says that I want the financial help, and he has provided 70 lakhs. But nowhere in the it is said that he is the power of attorney holder of mine, because it shows that this is a transaction. It's a financial transaction, my lord. There's no intent of criminality, my lord. So 420 will not come here in, my lord. Because the element of 420, while the indigence of 420 is very conscious that intention must be there. That I, by somehow, in some way, I have cheated him. But it is he himself has stated that I want the loan and he wants to, he has repaid me. He has paid me 75 lakhs, which according to him, I have not returned. So he has, after 2008, in 2015, he filed the criminal case under 420. So it is purely a civil nature. He has come up with the criminal case for recovery. The first point is that, my lord, he should have come with a clean hand by stating the fact that has been power of attorney. He is to operate my accounts. He'll check all the bills and all will be withdrawn by him. He has not given those things. Straightway he has said this because I'm sure that this amount was drawn from some other bank. Now, so for the loan is concerned, for suppression of facts, I will rely on one decision. That is Ramadas Foundations. I will rely on one decision, my lord, of the suppression of facts, which has clearly stated in para 14. Para 14. The principle that a person who does not come to the court with a clean hand is not entitled to be heard on merits of his grievances, and in any case, such person are not entitled to any relief is applicable not only to the petition filed under 32 Article 32, 221, 36, but also in the case instituted other court and the judicial power. So in the criminal case also, my lord, he has to come with a clean hand. The subject underlying the principle is that every court is not only the object underlying the principle is that every court is not only entitled but is a duty bound to protect itself from the unscrupulous litigations who do not have any respect for truth and who try to pollute the stream of justice by resorting to the falsehood or by making a misstatement or by suppressing the fact which bearing on the adjudications on the issue. So, my lord, Apex Court has clearly stated that in the complaint he ought to have written a letter, a sentence that I am the one of the attorney holder of him, and he has taken the loan from me. Those facts. So, on this ground alone, this complaint is to be thrown out. Now, this is one submission. Now, my lord, next submission will have civil nature. If it is, my lord, civil nature, my lord, I will come under two decisions. My lord, already I think there is on last occasion, Justice which only has taken a judgment here. The lordship has got it in the record. Not that. In the record completed. Even then, I will submit to it. Not that. It is, my lord, 2022, my lord. Vijay Kumar High Verges, State of West Bengal, my lord. Straightway I will come to the para 34. My lord, lot of cases are discussion about the civil nature. Then, my lord, 34. A breach of contract cannot give rise to the criminal prosecution. The head notice. Fraudulent or dishonest intention is the basis of the offense of the cheating. Now, my lord, your lordship will take up the petition. Complaint petition. Let them show any statement they have made that I have cheated them by intention. What are the grounds? Nothing. Your lordship will come. I'll read over those agreements. The statement. 75 to the accused person returnable by executing the deed of agreement, that is 248, and money received and resident complaint Itanagar so and so. My lord, the humble complainant beg to state the loan amount was taken by for investment in the building construction. Your Lordship, the power attorney, para 4, that the humble complainant beg to state the loan amount, para 4 of the complaint, of the complainant was taken for investment purpose for building construction work at JNKV. Now your lordship got it. He has given me the loan, he says 75 lakhs. He is being my power of attorney holder. He is to operate all the accounts. Those facts are suppressed in the complaint. He never stated that. Now your lordship will come and promise to pay back the loan amount after the completion of said work. Now, where is the intention, my lord, of cheating 420? The entire ingredients of 420, if your lordship goes to the IPC of 415, my lord, there must be an intention to cheat him by making false statement, by inducing him. But here he himself admitted that he did not say that his power of attorney. In the completion, he said that I have given him a loan with the promise that he will give me the loan back. And if I don't pay the loan back, you go and file the civil suit. From 2008, 2015, you are. And thereafter, when you find that there's a time bar case, you take the help of criminal case under 420. And nowhere it is in the completion, he says that intention. He is only one, the recovery of his money. So the Supreme Court has rightly held in 2002, because it's a breach of contract. If he wants to say so, 406, if there's any inducement, nothing is there. So breach of contract cannot give rise to the criminal prosecution for cheating. Fraudulent or dishonest intention is the basis of the offense of cheating. A mere breach of contract is not itself is a criminal offense and gives rise to the civil liability and damage. As I have stated, you ought to have gone to the civil court. This is one of the judgment. Another two judgment of our High Court, same matter. Oh, another Supreme Court, sorry. This is also 2023, my lord. Paragraph 13 and 14. A breach of contract does not give rise to the criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of transaction. Now, where is that he has shown in the complaint petition, my lord? He says that he has given the loan. With that loan, he will construct he being the power of attorney, he will use it for construction of this building and all. I have not paid the money, it is separate issue. But where is the cheating, man? From the facts on the record, it is evident the respondent number 2 has improved his case. Ever since first complaint was filed with, there was no allegation against the appellant. Rather, it is only against the property dealer who has subsequently complained. The name of the appellant was on the first complaint so and so. Here, in our opinion, the impugn order passed by the High Court deserved to be set aside. The petition filed by the appellant for quashing the FIR is ordered to be allowed. So, my lord, here is this case also. The Supreme Court has said that such type of is to be quashed by. Our High Court, there are many decisions, my lord, but I will not like to praise those things. Our High Court in two of its decisions, in 2014, by Justice A.K. Goswami, 115 and 420, cheating, dishonest, inducement, accused petitioner took loan from the complainant with promise to refund. Here is the same matter. On a given date, check issued and disbursement loan, but dishonor, check complaint filed a petition alleging under 420 maintenance fee, no disclosure in the complaint petition about the dishonest and fraudulent indication. Now, I have shown that in the complaint, there's nothing about that, how I have treated it. Only he said I have given him the loan, he has not paid me the loan, I want to recover them. Dishonest and interest at the time of taking loan and since order to attract the offense of the person. That is one, and another is by the Justice Ajit Bhattakur. The same minor, same is minor. Hook washing, 434, allegation of refusal to pay share due out of the bill amount drawn in respect of execution of contractual work. Same here also. Being the attorney, he executed the work on behalf of me. According to him, he has given me the loan, 75 lakhs. I have not given him, but I have given him all the authorization to take the amount from the cash, to deal with the cash and everything. So where is the question of cheating, my lord? So these are the judgment. And lastly, my lord, my little submission, my lord, about the 202 jurisdiction. But these earlier 2 points are okay, my lord. 202, my lord. If your lordship takes the complaint case file, the court under 202, if the complaint, if the accused is just outside the jurisdiction of the magistrate, the lordship is then the notice is to be issued either to the police or to someone to investigate the matter. And when the police file the report, on basis of that, the complaint should have been registered. But here, your lordship will find they have a straightway, they take the evidence, the affidavit of the complainant and issue the summons and arrest the court. In this case, straightway, the cognizance was taken. I read the order, man. I read the order. That is your order dated 7 to 19. Learned counsel for the complainant has page 26 of the petition. Learned counsel of the Tagum is present with the complainant Tagum. Today is the case fixed for necessary order. The complaint was examined under section 200 on 28/1/19. The case has been filed against the accused Madhav Shah and Anayam alleging inter alia that they have borrowed. Now here also they have borrowed. See the funny, they have borrowed. The court himself admits it's a borrowed, the loan transaction. So no element of criminality is there. Borrowed an amount of 70 lakh plus without the intent, with an intention to return the same, without any intention to return the same. Heard the learned counsel also perused. Upon hearing and peruse the case record, this court found prima facie to initiate the criminal proceeding against the accused person for cheating, according to cognizance hereby taken against so and so. Now here, the Supreme Court has said, my lord, under 202, when he was the complaint accused is outside his jurisdiction, either he must make a investigations, record the statement, and thereafter he has to make the cognizance. But here it is not done so, because your lordship, I'll place a judgment of our High Court. That is the famous judgment, Dr. Subramanian Swamy, at the state of Assam. That your lordship will find paragraph 12 onwards, man. Paragraph 12 onwards. The word, my lord, let me go through that. 11 onwards, my lord. This is an indictment given. The 202 postponement issue of the process. Then your lordship will come to the paragraph 12. The word shall, in case where the accused is residing at a place beyond the area on which he exercised his jurisdiction, have been inserted in the section 202 of the code by the section 19 of the Criminal Procedure Code with effect from 23/6/2006. The note for amendment read as under. False complaints are filed against the person residing in a far off place simply to harass them. In order to see that innocent people are not harassed by the unscrupulous person, this clause seeks to amend the subsection 1 of the 2002 to make it obligatory upon the magistrate that before summoning the accused residing beyond his jurisdiction, he shall enter into the case himself or direct investigation to be made by the police officer or such other person as he thinks fit for finding out whether there was a sufficient ground for proceeding against the accused. The above insertion in section 202 has been considered in number of cases by the Honorable Supreme Court, including the Uday Shankar Suwan given there. So here admittedly, the magistrate taking the cognizance without funding investigations, without asserting the truth, is unconstitutional. As per the hit by the section 202, that is the jurisdiction matter. So my respectful submission, this is the third point, that is why I'm not taking emphasis, because though it is 202, they have to court to have someone in, it can be remanded back and on. But the question is about the intention, cheating, suppression of facts. So my respectful submission, my lord, this complaint case is need to be quashed, my lord, because this is legal remedies for recovery of the loan amount. You cannot come under 420. There's other decisions are also there. Similarly, my lord, I can place those things, but it will be too much, my lord. If your lordship wants for your just economic discussion, I can give you. This is also Supreme Court 2008. All the decisions are held like that, my lord. Where the accused is a criminal prosecution under 420, alleged to have been only refusing to return the money. Here also I refuse to, this says I refuse to, but if your lordship goes through the, I'm not going into those documents under 482. But if your lordship will go to the statement in the complaint petition, you'll find that he never said that I have cheated him. He says that I refuse to pay. And if I go back behind those documents, my lord, that is what he has given the legal notice. Even then it will show that I have already returned certain money amount. It is not that I have not returned. It is admitted in his legal notice itself that you have paid out of so much, you have paid this much. So your remaining balance is there. So where is 420 coming from? This judgment is also right. So on this ground alone, this petition has to be passed. This allowed should be allowed and cause the complaints. That's my
Lordship, may I please? Lordship, this original complainant expired. And after expired of the original complainant, a legal hire was implemented in this case. So in this case, Lordship, originally arising out of the amount 75 lakhs amount was given by the complainant to the accused person. There is two accused person, two debtor was there, and the complainant was the creditor. And that amount, particularly, Lordship, kindly the agreement, that amount is of public money. Then the complainant was the MLA, member of Legislative Assembly of 16 years to constituency, Lord Suvan district. And during the time of his MLA, he took a loan against his firm, MS JT Sawmill, having CC account number 43 of Arunachal Pradesh Cooperative Bank, New Delhi, against his Jeti Sawmill, he obtained loan from the bank and given to the petitioner with the condition that that amount to be returned after some period. Now the petitioner bring some documents before the Honorable Court saying that there was a power of attorney, but in fact that power of attorney was not acknowledged to the original complainant. Before initiation of CR case number 131 pending before the Learned Court JMFC UPR. After filing of original complaint case number 131 of pending before the JMFC court, the recovery officer from the bank side issued a repeated notice to the original complainant to return that amount. I have filed that notice in my petition, implement affidavit opposition, affidavit in opposition filed by the private respondent. I enclose that order issued by the recovery officer, page number 10, Annexure B. Many notice issued from the recovery officer. Page number 10, my affidavit in opposition, Annexure B. Order dated 13/12/19. Order dated 13/12/19. I have enclosed the affidavit in opposition filed by the private respondent. Lordship, this clearly indicate that the order dated 13/12/19 perused the case, the certificate debtor Sri Toko Takam, MSJT Sawmill present, that is the original complainant. The court is refixed for hearing on 30th June 2028, so and so. Also present the Chief Photo Legal Counsel, Apex Bank, and Sri K. Mili, so and so, so and so. This order is passed under my seal and signature. Lordship, this is clearly indicated that Sawmill, the owner of the MSJT Sawmill, that is the original complainant, obtained loan 75 lakhs amount from the bank, and that amount has given to the present petitioner. Now, question is that amount Lordship, if we peruse the agreement entered between the complainant and the present petitioner, in petition submitted, criminal petition page number 20 submitted by the petitioner. Here is also clearly indicated that page number 20, agreement dated 39/8. The deed of agreement is made on this day of 2nd April 2003. Here somewhere written 2008 or somewhere written 2003. In between Sri Mehtab Saha, son of late Gur Gopal Saha, resident of 526, so and so, so and so, and Sri Jotam Tokotaka, so and so. The first party has taken some of rupees 75 lakhs from the second party during 2003 out of loan amount given to the second party, so and so, against the account of MSJT Sawmill having CC account number 43 Arunachal Pradesh Cooperative Apex Bank, New Delhi, on returnable basis. Here also Lordship clearly indicated that, and next last para also, the first party had agreed to pay back the said amount, that is rupees 75 lakhs, along with interest accrued against the said amount to the second party or directly to the Arunachal Pradesh Cooperative Apex Bank branch New Delhi against the CC account number 43. Here, way of returning is clearly indicated mentioned. That means here, Lordship here clearly indicating that that amount was obtained from the bank and that amount is public money, public money. So, after obtaining of this loan amount, the present complainant, the present petitioner executed the work, JNB work actually, and obtained the loan amount from the concerned authority. Again, when work was completed, the present complainant disappeared from the Arunachal Pradesh and go back to their native home. And legal notice, of course, legal notice was served to them, but not received. And the frequently phone number was changed and residence was changed. And also here residence also, Lordship, not clearly disclosed where the petitioner is residing, not disclosed. In my as per reliable sources, their place of residing as per petition, place of residing is residing at Navagram PO Panch Pota, Kolkata 152 PS Sonapur. But after physical inspection, that address we repeatedly visited there but not found. But their address is written as yes, at his detailed address is at plate number T72/4 Ruchara Residency 369 Kolkata Road, North Purvachal, Haltu, Kolkata 70078. They are mentioned in the present address in their petition is different, and originally she residing in different. The intention is clear cut shown. They are after availing the loan, after completion of the contract work, intentionally shifted their home address frequently and phone number was changing frequently. That's why legal notice was served but could not receive, could not serve properly to the alleged person. Moreover, Lordship, there is two accused person. One person is ready to contest the CR case. One person is ready to contest the CR case pending before the GMFC Court UPR. Now the another accused person is not ready to contest the case pending before the GMFC Court. So my Lordship, here initially they are during the time of entering the agreement and giving the loan amount to the petitioner. Initially were not such a criminal intention might not be there, but after availing the loan and after completion of the contract work, he not fulfill or comply the age party agreement, and he hiding frequently and changing their address and phone number. As my learned senior counsel submitted that since the matter is civil in nature, though of course there may be civil in nature, but on the ground of civil in nature dispute, this honorable court cannot invoke under 482 to quash the pending CR case before the GMFC Court. You fear. Lordship, I have a decision rendered by the Honorable Supreme Court passed in criminal appeal number so and so arising out of SPL so here Supreme Court, in case of Dr. Laxman versus the state of Karnataka on 17 October 2019. Page number 3, para 9 here clearly stated that in case of civil in nature or in case of pending the civil case pending before the trial court, pending before the court for recovery of that cheated amount is not a ground for invoking under section 482 of the CRPC. Their intention, the mens rea is clearly rendered that the way of obtaining loan and the promise to return the amount is not fulfilled by the petitioner. It is clearly the ingredient is there to cheat the complainant, wrongfully gain by the petitioner and wrongfully cause loss to the complainant. And with this, Lordship, my humble prayer before this humble court, that since the loan amount is of not the private money, is of public money, though the original complaint is expired, but notice from the bank is repeatedly served to the legal hire to recovery of that amount. If the this honorable court allow the petitioner to quash the criminal case pending before the JMFC Court UPA, there will be loss to the even entire public because that amount is of the public bank amount, the bank money, that is ours money. So if the petitioner ready to pay, then there will be no problem. Otherwise, it will be lost to the entire common public. And so my prayer would be this petition may not be accepted and their place of residing is also not properly mentioned. So, and there another one new things, the agreement, power of attorney zone is also disputed because that then period, the petitioner MLA, the MLA cannot be entered that the negotiable instrument or the power of attorney. It is totally forged document. It cannot be realized. So finally, I pray this petition may be dismissed.
Yes. Submit reply.
Government will submit this.
My lord, in this case, all the factual part has been already submitted by the council for the respective parties, my lord. I'm only confined to very limited points, my lord, since they are the contesting parties in this case. First part, my lord, in this case, there are certain lacunas on the part of the learned trial court below in not complying with section 202. My lord. What are the remedies when a complaint is filed before the trial court, my lord? Firstly, my lord, record the deposition under section 200 of the CRPC, and if a private facie case is being found, a process can be issued under section 204. And if at all the magistrate is not inclined to issue a process, can postpone the issue of process under 202 and give a direction to the magistrate or any other person as he deems fit to incur the matter and submit the report. But since there is a specific provision under 202 stating that, my lord, if the accused is not within his jurisdiction, my lord, in that the circumstances, my lord, the matter has to be postponed. Issue cannot be processed, and inquiry has to be done by himself or by the direction to the investigating officer, which has not been done in this case. And I don't think, my lord, that can vitiate the whole trial proceeding, my lord. That is to my understanding, is a curable defect, my lord. And the second issue which they have raised, my lord, stating that it has a civil flavor and it has been given the criminal color. But to that effect, my lord, even that issue is also no more as integral, my lord. That has been decided in various authorities, my lord. I won't trouble, my lord. I'll just place one authority into that aspect. Was reported in 2020, 14 SCC 552. K. Jagdish versus Udaya Kumar GS and another. May I take my lord to paragraph 8 of the judgment, my lord? This has been. Para 8. It is thus well settled that in certain cases, the very same set of facts may give rise to the remedies in civil as well as in criminal proceeding. And even if a civil remedy is availed by a party, he is not precluded from setting in motion the proceeding in criminal law. In Pratibha Rani versus Suraj Kumar, this court sum up the distinction between the two remedies as under. There are a large number of cases where criminal law and civil law can run side by side. The two remedies are not mutually exclusive, but clearly co-extensive and essentially differ in their content and consequence. The object of the criminal law is to punish an offender who commits an offense against a person, property, or the state, for which the accused, on proof of the offense, is deprived of his liberty, in some cases even his life. This does not, however, affect the civil remedies at all for suing the wrongdoer in cases like arson, accident, etc. It is an anathema to suppose that when a civil remedy is available, a criminal prosecution is completely barred. The two types of actions are quite different in content, scope, and import. It is not at all intelligible to us to take the stand that if the husband dishonestly misappropriates the stolen property of his wife, though kept in his custody, that would bar prosecution under section 406 IPC or render the ingredients of 405 IPC nugatory or abortive. To say that because of the strident of a married woman is kept in the custody of her husband, no action against him can be taken as no offense is committed, is to override the distort the real intent of the law. In Rajesh Bajaj versus State, NCT of Delhi, this court observed, it may be that facts narrated in the present complaint would as well reveal a commercial transaction or a money transaction. But that is hardly a reason for holding that the offense of cheating would elude from such a transaction. In fact, many cheatings were committed in the course of commercial and also money transaction. One of the illustrations set out under section 415 of the Indian Penal Code, 1860, is worthy of notice now. A intentionally deceives Jet into a belief that A means to repay any money that Jet may lend to him, and thereby dishonestly induces Jet to lend him money. A not intending to repay, A cheats, my lord, which is quite similar to this case, my lord. The crux of the postulate is the intention of a person who induces the victim of his representation and not the nature of a transaction which would become decisive in discerning whether there was a commission of offense or not. The complainant has stated in the body of the complaint that he was induced to believe that the respondent would honor payment on receipt of invoices, and that the complainant realized later that the intention of the respondent were not clear. He also mentioned that the respondent, after receiving the goods, had sold them to others, and still he did not pay the money. Such averments would prima facie make out a case for investigation by the authorities. The High Court seems to have adopted a strictly hyper-technical approach and sieved the complaint through a calendar of finance clauses for testing the ingredients under section 415 IPC. Such an endeavor may be justified during trial, but certainly not during the stage of investigation. At any rate, it is too premature a stage for the High Court to step in and stall the investigation by declaring that it is commercial transaction, simplicity wherein no semblance of criminal offense is involved. The aforesaid view was reiterated in Kamala Devi Agarwal versus State of West Bengal. Stated that criminal prosecution cannot be thwarted at the initial stage merely because civil proceedings are also pending, after referring to the judgment and so and so. Now, lastly, my lord, para 12. After referring to the various judgment, it was finally concluded as under. In view of the preponderance of authorities to the contrary, we are satisfied that the High Court was not justified in quashing the proceeding initiated by the appellant against the respondent. We are also not impressed by the argument that the civil suit was pending in the High Court. The magistrate was not justified to proceed with the criminal case either in law or on the basis of property. Criminal cases have to be proceeded within accordance with the procedure as prescribed under the Code of Criminal Procedure, and the pendency of civil action in different court, even though higher in status than authority, cannot be made basis for the quashing of proceeding. Only this judgment I would rely on. Otherwise, my lord, regarding the intention, the ingredients of section 420, my lord, that can only be decided after adducing the evidence in the proper trial of the court, my lord. At this stage, my lord, it would be too premature to decide those issues, my lord. Since apparently prima facie from the face of the record, but it reveals the fact that he has taken 75 lakhs of rupees and he has not returned as of today. That can only be decided by adducing evidence before the trial court, my lord. And repeatedly, my lord, we are making a submission, my lord, that the High Court cannot conduct a mini trial. So similarly, my lord, everything has to be decided by the trial court. If they have an issue and if they have documents, my lord, they can place it before the trial court and they can get a
That's all.
Yes, my lord. What my learned friend has said is. First I will take up with my learned friend, private respondent. My lord, it is a settled law by the thrill of things. What constitute and co if I am not wrong, my lord, the number of decisions have been followed by the present law. It is the masterpiece. First thing is, my lord, from the plain reading of the complaint, one has to show the intention. Now, the complaint is before your lordship. Let them show a single line, my lord, that I have an intention to cheat. All along in the apartment, they are saying that I have not paid their amount. Admitted, I am not saying. Suppose I admitted, he has given me the loan, 75 lakhs. I have given him the power of attorney to do the transaction. My lord, where is the intention of cheating, my lord? Because under the IPC, the intention must be there, my lord. When I am giving a power of attorney blankly to operate my account, so where is the question of cheating, my lord? That individual doesn't come in. When the individual is not in the competition, my lord, how the court can take the cognizance? That is what the personal law says. You cannot take the cognizance so moto without having individuals. We must satisfy the court that there is a prima facie, yes, the intention is there. He himself admitted in the notice that I have paid the amount. So in that respect, what the learned friend has submitted, our High Court as well as Supreme Court has clearly stated recovery of loan cannot be under 420 months. Otherwise, then every bank will file a case before the every loaner under 420. It's going to the DRT or civil court. Everybody will file that. Bank will not come for the civil process. Just will file the 420, you pay the money. You have taken the loan for building, you pay the money by 420. That is not the law, my lord. Law says that to go for a criminal prosecution, my lord, you must satisfy the indigence. Second question, what the learned friend says about the section, my lord, that is jurisdiction about the section, I said 202, section 202. My lord, the Subramanian Swamy's case, which our High Court has quashed the FIR and has quashed the complaint also under 226. If your lordship goes through the judgment paragraphs, my lord, you'll find number of Supreme Court decisions have been said when the magistrate fails to go by the law, by prosecuting, the court has the power to prosecute. You cannot reset again after you taking the cognizance. You cannot go for the fresh trial again after taking the cognizance. Before taking the cognizance, you must satisfy all the section which has been given. That is why I say shall. That is amended in 2006. Otherwise, it was. But when the word shall has come, it is the mandatory duty on the part of the magistrate to make the further investigation. Even in the matrimonial cases, my lord, even in the matrimonial cases of the family law, my lord, under say Dowry Act and all, my lord, if the cognizance is to take it, this is outside the jurisdiction, then the magistrate should ask the police officer to record the statement of the accused and submit it to the court so that prima facie case can be taken place. Here I have shown without giving anything, straight away the magistrate has taken the cognizance. On the basis of what? On his mere statement. Why have they not produced the power of attorney, my lord? It is in their custody. It is not a suppression of facts. And he himself admitted this complainant that I have given him the loan. Now, my lord, here is another judgment, my lord, of 2021, my lord. Repeated, don't repeat. Lordship 35, 30, so paragraph 35, 35, 37, 38, 41, 45, 47, 48. This will answer to my landed government meeting. These paragraphs will answer this matter, 2021, because he says of the civil nature. Yes, had they have been filed the civil case pending, title money suit is pending in the court, then the question would definitely arise. They have not filed the civil. They have not filed the money suit in the civil court manner. Their petition itself will show. They want to take the reports of criminal procedure to recover them. How far it is justified under the criminal jurisprudence? That is the law. I'm to say that. You cannot walk the civil nature with the criminality. These are two different branches. That's all, man. See, should I this judgment which I will, should I name on the top of it, should I write that this is for the
No,
petition?
I have.
Oh, that's okay. That should be done for that. So,
I have.
and all like them.
You'll be returning today?
Yeah. It's,
Why? What more?
tomorrow there is a POSCO matter is there. For them. Just. Have you ever?